Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Shipping Law Review United Kingdom, England and Wales. So this is the fourth part of the video. Cargo claims. The bill of lading evidences a contract for carriage obligating the carrier to deliver cargo against that document. Aside from charter parties, bills of lading are the fundamental element of cargo claims under English law. A common basis for English law cargo claims is the breach by the carrier for the duty under Article 3, Section 1 or 3, Section 3 of the Hague Rules. Pursuant to the Carriage of Goods by Sea Act 1992, which is applicable to bills of lading, seaway bills and ship delivery order, title to issue is vested in the lawful holder of the bill of lading. The lawful holder is the person who becomes the holder on the bill in good faith. There is a consignee or endorser following a valid endorsement or chain of endorsement in possession of the bill. The AWCA confirmed that the bank that is the pledge of goods under a letter of credit can also be classed as a lawful holder of the bill of lading because it is entirely entitled to those goods. The party that is potentially liable for the cargo claims under the bill of lading is the carrier stated under the bill. Typically, this is the shipowner or head time charterer. English law will generally give effect to identify and carrier and demise clauses in the bill of lading, which can seek to make clear that it is the shipowner that is to be regarded as the carrier under the bill, although the issue of on whose behalf the bill have been signed will also be an important factor in deciding who is actually the carrier. Liability in tort, that is, a breach of duty to take reasonable care not to cause damage or loss, in example negligence, will usually be asserted by any cargo claimant against the ship owner, and may also arise between parties where no contractual relationship exists, for example between stevedores and cargo owners. The claimant must be able to prove physical loss or damage and so cannot claim to pure financial losses in the absence of any cargo loss or damage, for example in the event of cargo delay. Furthermore, only the person who owned the cargo or was entitled to possession at the time of the Negligence Act may claim. Apart from tortious liability, English law also recognizes the effectiveness of Himalaya clauses in bills of lading in the context of losses caused by the acts of stevedore. For a deeper analysis of Himalaya clauses, see the Port and Terminals chapter. When bills of lading are issued in respect of carriage on the charter vessel, carrier may attempt to limit liability to cargo owner with reference to a charter party by expressively incorporating terms of the charter party into the issue bill of lading. Provisions incorporating charter party terms into bill of lading will be recognized only if they are relevant to the bill of lading contract, and terms subject to choice or rule of jurisdiction including arbitration may be expressly referred if they are to apply. There is general presumption that terms in a charter party will not be upheld if they are inconsistent with the terms of bill of lading. Parties will often attempt to incorporate the terms of the charter party into the bill of lading. However, this will be successful only in following cases: where the wording supporting to incorporate the charter party terms is sufficiently accommodating, but the terms of the charter party being incorporated makes sense in the context of bill of lading, and where the incorporated terms is consistent with the terms of the bill of lading itself. It is important when trying to incorporate charter party terms into a bill of lading to refer to the exact charter party in question, as the charter may not otherwise be incorporated effectively. There is a presumption that in circumstances in which the parties fail to specify which charter party in a chain is being incorporated in the bill of lading, the held charter party is incorporated, but that presumption is subject to several exceptions. Cargo claim can also be brought under charter parties. They will usually be made within the framework of the equities bureaus, which have usually been incorporated into the charter by contract. The apportionment of liability for cargo claims as between owners and charter who are paid to a dry bulk time charter is often governed by the International Group of B&I Clubs, Interclub New York Produce Exchange Agreement. For limitation of liability, the earliest legislation entitled ship owner to limit their liability was the Subject Act 1733. This permitted ship owner to limit this liability to the value of the ship and freight in respect debt by a master of crew. Subsequent legislation seeks to strike a balance between a claimant's right to be compensated adequately in a low situation, cost of adequate high limitation fund to be affordable. The Conventions on Limitation of Liability for Maritime Claims 1970 The Conventions on Limitation of Liability for Maritime Claims 1976, the LLMC Conventions 1976 was given effect in the United Kingdom by the virtue of the MSA 1995 and is incorporated the schedule thereof. The protocol to amend the LLMC Convention 1996 was given effect in the United Kingdom by Statutory Instrument 1998 number 1258, which varied the LLMC Conventions 1976 and Schedule 7 of the MSA 1995 to the extent to set out the problem. The protocol is to raise the limits. As from 8 June 2015, the limits under the 1996 LLMC protocol have automatically been increased by 51% through the licit acceptance procedure. Who can limit liability and what claims are subject to limitation? Under the 1996 LLMC protocol, ship owner and selfers may limit their liability in accordance Ship owner and selfers may limit their liability in accordance with the rules of the protocol. The definition of ship owner under Article 1 includes the owner, charter, manager, or operator of a seagoing ship. Each of those terms require classification, and the Court of Appeal has now provided much needed guidance on the meaning of an operator within the limitation convention. With its decisions that the terms of operator, the machinery of the vessel, or providing event, providing personnel. So the time is up and the article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe. Bye.